Hello, it's such a pleasure to speak at Data for Policy Brussels 2022. I'm going to share my presentation now, just a moment. Well, yeah, it's all good. So today I'm going to talk about stimulating innovation through data protection regulations. That's a submission 8194. My name is Renan Gadoni Canaan, and I'm based at the Center for Law, Technology and Society at the University of Ottawa. So here we have a few teasers of this presentation. Basically, we conclude that reproducing GDPR into the Brazilian data protection regulation, which is called LGPD, actually compels firms to innovate. However, Western, to the detriment of Brazilian firms, appropriate the economic benefit of innovation in the Brazilian market. And we advocate that to rebalance opportunities for Brazilian firms, we need to implement local content policy for privacy-enhancing technologies in the Brazilian market. So first of all, we need to talk about the data protection regulations. Basically, the collection of personal data in the digitalized world has caused so many consequences for privacy and dignity interests. So we could give examples such as algorithmic discrimination and other manifestations of surveillance capitalism. That's why many countries, they legally responded to these privacy challenges by enacting data protection regulations. And those data protection regulations, they entitle individuals to restrict personal data processing by third parties. And for the purpose of this research, we're going to talk about GDPR, which is the European General Data Protection Regulation. It was introduced in 2016 and fully implemented in 2018. And we're also going to talk about the Brazilian Data Protection Law, the LGPD, which was implemented in 2018 after the Cambridge Analytica case. And the law was fully implemented in August 2020. Data protection regulations, they have the objective of ensuring data privacy for natural persons. And this objective is known as the manifest function of the law. It's because legislators, they clearly recognize it in the statute. And this objective informs judges on how to interpret the regulation. However, legal statutes and regulations often present functions that are unknown to lawmakers or judges. And these unintended functionalities, they are known as the latent functions of the law, and they oppose to the manifest function of the law. Those latent functions of the law, for being previously unrecognizable, they provide researchers with very fruitful insights into the studied legal regime. In this case, the case of this research, data protection regulations. So keeping with this distinction between manifest and latent function of the law, many scholars, they assess an interesting latent function of data protection regulations, which is modulating technological innovation. More specifically, these regulations, they impact differently like two technological branches. One of them is data-driven innovation, and the other one is data protection innovation. So this distinction is very important. So data-driven innovation consists of the use of big data to improve production or distribution and better match customers' preferences. So we have many cases of artificial intelligence, blockchain, cloud computing. In turn, data protection innovations, they create market value through greater protection of personal data. Here we have examples on how data protection regulations impact each one of those branches. In the case of data-driven innovation, A stricter data protection regulation, they will raise the standards and costs for data processing, and this will consequently hinder new data-driven innovation. And also on the other side, data monopolies, they hamper innovation by preventing entrepreneurs from accessing the large data sets that function as fuel for data-driven innovation. So in that case, data protection regulations, they're going to incentivize data-driven innovation because they are going to empower data subjects with two important rights, the portability and the erasure rights. And with those rights, the individuals, they can challenge the data monopolies and those big and large data sets that are concentrated by very few companies. Concerning the second branch of innovations that are impacted by data protection regulations, the data protection innovations, we can say that firms, they demand more of this kind of innovations to comply with data protection law. And also data protection regulations, they compel firms to stand out from their competitors. Firms, they want to show to customers that, that they're more effective to protect sensitive personal data. So this is going to stimulate them to innovate because they want to stand out from their competitors. Both arguments, they lead to stimulating data protection innovations and a very specific field called the privacy enhancing technologies, or PETs as they are known. Another very important point to debate in this article is the replication of the European GDPR into the Brazilian LGPD. We understand that legal regimes naturally influence each other, and data protection regimes are no exception. So it's not a surprise that Brazil has reproduced the European data protection regime. However, the GDPR's influence over its Brazilian counterpart actually stems from the long-lasting European dominance of the third world. Many scholars emerging from developing countries, they posit that modern forms of domination over the third world or a continuation of the previous ones practiced in the pre-colonial and colonial periods. So these scholars, they belong to political and intellectual movement named Third World Approaches to International Law, also known by the acronym of the TWAIL. These TWAIL scholars, they claim that after an extensive period of political and economic domination of the third world, the European worldview dominates the imaginary of former colonies. Imaginaries, they are structures of subjectivity that inform the collective discourse. In turn, social institutions such as the legal corpus, for not existing separately from collective discourses that give meaning to them, they're also informed by those imaginaries. And Europe embedded its worldview in the third world legal institutions, and Eurocentric topics command the third world's teaching of law and governability, this connecting legal reasoning with local problems. And consequently, the third world sees the European legal system as a role model, and lawmakers, whenever they face legal claims, they will search for legal inspiration in Europe. And this mechanism is called emulation or lesson drawing. And the second argument is that replicating European regimes into the global South actually takes place through indirect imposition, since the European Union threatens third world countries with sanctions if they flout European rules. So therefore, third world countries voluntarily transplant exogenous European legal rules into their legislation. And the scholars, they call it the Brussels effect. And it refers to the fact that the European Union can expand its legislation across borders. and they can set new standards in international governance. And this will cause like a unilateral regulatory globalization. In the context of data protection regulations, the Brussels effect occurs through economic sanctions because since countries, they refuse to comply with minimum European data protection requirements, they are sanctioned to do business in the European Union. Therefore, the EU expands its data protection standards beyond its borders. Since the Brazilian data protection regulation has replicated the European data protection regime, and since data protection regulations stimulate innovation, so the research question we want to address in this paper is, does the replication of GDPR into LGPD stimulate innovation in Brazil? To address this question, we are going to use a TWAIL methodological approach. And this methodological approach abides by 3 principles. So the first one, the TWAIL approach historicizes the unbalanced relationship between former colonies and colonizing countries, and it uses it as a lens to analyze current issues in law scholarship. So it perfectly fits this research because this research accounts for the subaltern relationship between Brazil and European countries and replicating data protection regimes. Also, the second principle this research abides by is the fact that TWAIL approach embraces the transdisciplinarity, and this paper keeps with this principle by using theoretical frameworks of innovation studies. And we use this theoretical framework to explain the causal relations between the data protection regulations and the firm's innovative performance. And third, the TWAIL methodology posits that scholars should suspect universalizing narratives. And that principle is followed by this paper because we contest that the European model is per se the ultimate efficient version of data protection regulations to the entire world. The analysis of this paper demonstrated that replicating GDPR's principles into LGPD really fosters privacy-enhanced innovation in Brazil. In fact, all the empirical evidence points to the same direction. Because of LGPD, firms in Brazil, they bolstered innovative efforts in privacy-enhancing technologies. For example, in 2021, spending on security solutions surpassed $900 million in Brazil. That's an increase of 12.5% from one year to the other. And also, before implementing the Brazilian data protection regulation, no privacy technology vendor company operated in Brazil. But this, after the implementation of the data protection law in Brazil, the companies skyrocketed to 17 in 2021. So at least at the superficial level, one may conclude that looking beyond Brazil's borders to the European territory when facing data privacy legal challenges seemed righteous for Brazilian policymakers because it incentivized innovation. However, we must deepen this paper's analysis to address what kind of firms benefit from this regulation-based innovation simulation. So does replicating GDPR into LGBT foster privacy-enhanced innovation for domestic firms in Brazil? Here is a spoiler. Western firms, they appropriate the benefits of the Brazilian privacy-enhancing technologies market. The Western world, or simply the West, comprises European Union members and also Anglo-Saxon countries such as the UK, the US, and Canada. And in common, all those Western countries, they present high economic development levels, and they draw on high value goods and services that require high human capital and technology. And all those activities are known as knowledge intensive industries. The West in general has significant worldwide competitive advantages in knowledge intensive industries, and particularly in computer and information services. The privacy enhancing technologies sector, which is a branch of computer and information services, is also a knowledge intensive industry. And innovating in knowledge intensive industries depends on two conditions that are more favorable to Western firms, which is the first one, access to knowledge, and the second one is access to innovation funding. So first, regarding the access to knowledge, actually to develop high technology innovation, firms must seek knowledge from external sources such as universities, organizations, governments, and stakeholders. So the access to knowledge bolsters firms' innovative capabilities in high technology sectors, such as privacy enhancing technologies. These knowledge sources, as well as the ease of access to them, closely relate to the country where the firm is based. Western developed countries, they demonstrate much higher levels of knowledge and absorptive capabilities to tap into this knowledge stemming from the high human capital. So briefly, firms in Western developed countries, they manage to interconnect with such external sources of knowledge to innovate, overcoming all those third world countries. And second, regarding the access to innovation funding, any new firm's project entails risks, but technological innovation projects, they involve additional uncertainties. And to overcome those risks, firms, they require special funding instruments such as venture capital. The more access to venture capital, the better for knowledge-intensive, innovative firms. It happens that Western countries, they rank better in the venture capital's international landscape. For example, developed European Union countries, the UK, the US, and Canada, they all rank among the top 20 in the market sophistication and innovation investments. In turn, the third world lags behind. For example, Brazil ranks 75th among 132 countries. So consequently, venture capitalists, they target Western developed economies rather than the third world because they prefer more sophisticated and reliable capital market. Those two aspects discussed, they give advantages for Western firms to introduce new technologies in the privacy enhancing technology sector in Brazil. But besides that, Western firms, they also have advantages to secure those technological monopolies in the Brazilian market. And how does it happen exactly? So the Organization for Economic Cooperation and Development, known by the acronym of OECD, it represents the West's interests, the interests of Western countries, and they carve Western values in international manuals. So regarding innovation, OECD advocates that intellectual property rights, upon conferring a temporary exploitation monopoly of the protected invention, it compels inventors to invest in technological developments because they will somehow appropriate the economic benefits of that invention. The OECD materialized their interests in establishing a worldwide intellectual property system by requiring countries to sign the Agreement on Trade-Related Aspects of Intellectual Property Rights, known as TRIPS, the TRIPS Agreement. So to participate in the World Trade Organization, you need to sign the TRIPS. The TRIPS was created in 1994, and it sets minimum intellectual property requirements that countries should implement in the national legislation. So by 2022, more than 164 countries had already signed the TRIPS, and Brazil implemented its TRIPS compliant industrial property law in 1995. So through the TRIPS, the global north or the Western countries, they could set standards for intellectual property worldwide. And TWAIL scholars, they strongly critique the implications of intellectual property rules towards the third world. And why that? A global intellectual property system permits Western firms to have intellectual property over the inventions in any WTO, any World Trade Organization signature country. So it means that they can secure global properties. And furthermore, it allows Western firms to accumulate multiple patents on a specific technology in the global market. So consequently, domestic firms in the third world, such as Brazil, they face market entry barriers because some of their products and services, they rely on these technologies that are protected by multiple patents. So this entry barrier, known as patent thickets, they decrease the entry of new firms, particularly in technological fields such as privacy-enhancing technology markets. So through the multiple patents that block competition for domestic firms, the Western firms, which already have advantages to introduce privacy-enhancing technologies in emerging markets, they can secure technological monopolies. And as an example, OneTrust, it's an American company. It's the world leader in privacy-enhancing tools and the fastest growing company in America. They rely on more than 200 different patents to secure the technological monopoly of its privacy management platform. So this is a huge market barrier for emerging companies in. As we can see, the Western firms, they dominate the privacy enhancing technology market. So 7 Western firms only, they hold almost 80% of the worldwide data privacy compliance software market share, as you can see in the image. And specifically in the Brazilian market, the Western firms operating in Brazil, they increased from 0 to 17 in 2021. And this largely outnumbered the 4 domestic firms in Brazil. So there's an inequality of opportunities between domestic and Western firms, foreign firms, in accessing the Brazilian privacy enhancing market. And these unequal market opportunities between domestic and foreign firms, they advance the technological gap between the global and the global north and south. So something should be done. So in this case, we propose that one solution could be the local content policies. So what's that exactly? So local content policies, they require that companies to operate in the country, let's say in Brazil, they should purchase a portion of the operations inputs in the domestic market. So by creating a forced demand for domestic products, local content policies, they strengthen the domestic market and develop high potential technology intensive domestic firms. So consequently, they foster technological development as well as the technological know-how of domestic firms. Briefly, local content policies, they also create national champions, which are national companies that produce local technology and eventually export their products. So local content requirements, they have already effectively bolstered innovation in many sectors in Brazil. The most advanced discussion on the impact of local content policies on innovation in Brazil regards the gas and oil sector. Also, local content policies, they bolstered the eolic energy sector and the naval sector in Brazil. So the same way, we think that local content policies may boost the Brazilian privacy-enhancing technology market for domestic firms. We think that local content requirements for privacy-enhancing technologies could be applied through auctions, for example, such as the local content requirements in the oil and gas sector. We believe that the government could set percentages in the bid process, requiring a certain percentage of firms' costs to be represented by domestically developed privacy-enhancing technologies. This way, we could rebalance the opportunities for domestic firms in Brazil. So what are the conclusions and takeaways of this work? First of all, it's important to say that reproducing GDPR into LGPD stimulates privacy-enhancing technologies in Brazilian markets. However, Western rather than domestic firms take over the Brazilian market. So first, because the Western firms, they benefit from better access to knowledge within their national innovation environment. Second, they have easier access to venture capital, facilitating knowledge-intensive innovation, such as privacy-enhancing technologies. And also the Western firms, they can secure technological monopolies in Brazil by means of the patent system. All being said, to increase opportunities for domestic firms and decrease the technological gap between industrialized Western countries and Brazil, local content requirements for privacy-enhancing technologies should be implemented. And also Brazil should be critiqued on reproducing data protection regulations from Western countries. The country must reflect on whether such transplants fit local specificities. Thank you very much.